Cordts here, and we are with Jay Wright. He has run for Court of Appeals, District 9, which is based in Beaumont. It's Tuesday, December 17th. And thanks for coming in, Jay. And as we discussed, why don't you get us started with up to 5 minutes open?
All right. I am born and raised in Corpus Christi in 1959. And my wife, a little bit older than me, she was also born in Corpus Christi. And we were both in fairly large Catholic families. We had 10, they had 5. And we actually were baptized and confirmed and first communion at the same church. And then her family moved away to Ingleside. And then after I went to college and law school and came back to work in Corpus Christi as an assistant county attorney at the Wright County Attorney's Office, I met her on a blind date. By that time, she had grown up. She had graduated from Corpus Christi State University the year before I started there. And so I met her, and we fell in love, got married, and ended up having 4 daughters. 1 daughter and 3 tries of a boy. And after working at the county attorneys for 6 years, almost 7 years, nearly 7 years, my boss at the time who was a Democrat, was running for district attorney and going to win. And so I ran as a Republican in Corpus Christi, which was at the time there was only 1 elected countywide officer, and that was a Democrat who switched to Republican. So I ran in 1992 for my boss's spot, county attorney spot, and ended up coming in second, as they say, to a guy named Carl Lewis. He was an African-American defense lawyer, and that summer, the real Carl Lewis had won 5 gold medals at the Olympics, so he had the name recognition without ever spending a dime. And if you remember, Bush Sr. was dragging the ticket down that year, so even though I got thousands more votes than President Bush did, with Ross Perot in the mix, I still ended up losing. I'm glad to say that Nueces County, now pretty regular, although close, turned Republican. Now, like some folks, I think, give me a little bit of credit for working the team back then. But I had become a Republican when I was in college at Corpus Christi State University. My pediatrician when I was growing up, Dr. Lewis Conklin, ran for Congress in 82. Well, actually, I had become a Republican in 1980 because I had a Republican woman who was in her 60s, I believe, taking political science classes, and she gave me a ticket to go see Ronald Reagan at the airport in October of 1980. And so I had gotten a random supposed ticket to go see Jimmy Carter when he came to high school to have a town hall meeting. And I went and saw him, and he looked like death warmed over, and all the questions were pre-screened. It was obviously a setup, so Sam Donaldson, people like that. So that was like on a Thursday. Well, she gave me a ticket on Friday to go see Ronald Reagan on Monday. So it's sort of an independent night. So I go see Ronald Reagan, hear him speak, get a left-handed handshake at the airport. The man had piercing blue eyes, very soft skin. Obviously, he wore gloves when he chopped wood. And after that handshake, that was it. I was Republican. So in '82, I was working on Republican campaigns, and my pediatrician when I was growing up ran for Congress, Dr. Louis Conklin. So when I went to volunteer for him, he hired me to work the last 6 weeks of the campaign with him, going to parades and block walking and stuff like that. And after that, I ended up every 2 years for the next 5, I think, convention years, going to the county state conventions and being very active. I think I missed one term in the 90s, but then generally went every 2 years to the state conventions and was active in the local party. And like I say, in '92, I decided to run for county attorney. And in law. So I went into private practice in '93 and worked in Oasis County doing general things. When I was at the county attorney's, I had started as a prosecutor, and then after 2.5 years, our chief criminal section moved on. So I was appointed chief of the criminal prosecutors. And after about 2.5 years, I was kind of getting ready to, let's go out in private practice, and our civil chief left, so he made me chief of the civil division. So when I was criminal chief, I would prosecute the high profile, things we wanted to look closely at, and try to make sure the attorneys got to court and were prepared, and things like that. When I was civil chief, it was different. I would work on lawsuits defending the county on tort claims or federal lawsuits, and then write opinions and give legal advice to all the county department heads and things like that. And it was a very broad experience, which is why I think to this day I don't specialize in just one area of law, because when I left the county attorneys, by a vote of 55,000, 45,000, I went into private practice and generally tried to do civil most of the first year, and then started back into doing some criminal defense, and ended up doing employment law cases and civil litigation, business litigation, family law, and some criminal defense, and then some employment law, both defense and plaintiff side is generally goes federal. So I had federal cases also at the same time, and then my practice never whittled down into just one area. So I also would do my own appeals. A lot of attorneys who will go to a trial, jury or non-jury, they don't want to work on appeals because the rules are a little bit different, the timetables, and so. But I would always do my own appeals if I had a case where the other side I won and they appealed, or if I lost and I wanted to appeal, I'd go on and do the appellate brief, whether state or federal. And then I've had some attorneys that would call me and I don't do the appeals. Can you do it? And they'd hire me, or their client would hire me to do appeals. And so it's in the mix of things that I do. And so I've gotten a view of people's circumstances from all the different legal angles. Because I also used to do consumer bankruptcies, and about 10 or 12 years ago when I changed the bankruptcy law, it made it more difficult for people in Texas anyway to do a bankruptcy. And so I quit filing consumer bankruptcies, but I still do represent creditors now and then in bankruptcy. So what I have developed over 34 years is a very broad understanding of the law from very many aspects, so that I can understand, if I'm doing a family law case, what impact a property division is going to have on a potential bankruptcy if there's financial problems, things like that, and warn my clients that way. If I'm working on a bankruptcy case, I can warn my clients about the potential criminal pratfalls. Hey, wait a minute, if you don't say everything correctly in these schedules, then you could be facing federal prosecution over here. And so I have this, like I say, broad background experience. And I decided after looking at the field of who was running for this to replace Justice McKeithen in the Ninth Court of Appeals, that I didn't feel like, even though I know, personally, all but one of the candidates, I didn't feel they had the same background that I had. They certainly hadn't done the appellate work that I'd done, and not as broad a spectrum. Because I've had over 117 state appellate cases. I've had others that were not listed with the state office, that were Fifth Circuit, or that I've tried to send to the Supreme Court or something like that. And also my practice field is still much broader. Some of the candidates are civil only, someone I think is a criminal only, and so the question I had was, okay, if we're going to replace the Chief Justice, who should it be? What philosophy should they have? I had been pushing for many years, since reading David Barton's book on Original Intent back in the 90s when we were homeschooling our children. I'd read about how the original intent of the founders has been twisted and changed, okay? And I was very upset because, as I say to people, I was lied to in law school, told the Constitution is an organic document and that it has to change with the times, and so it's basically whatever the majority of the Supreme Court wants it to say, you know? So I was spoon-fed that in law school, and I thought that was the truth. And then when I read David Barton's book, I found out there's older, from 1800s case law, and even some early 1900s, that stuck with the original intent of the Constitution. And I'm like, we were never taught this in law school. This is completely wrong, what has been done. And over time, learned how it happened. Mark Levin had written a couple of books, Men in Black and I think in Meritopia, and he explained how the German school of philosophy was adopted by a lot of the liberal colleges, you know, Harvard, Yale, around the turn of the last century, and that they started educating the law students on changing the dynamic and getting away from natural law, okay? Because they were secular humanists. Humanists is what they were. And they went along with the old John Dewey, you know, Humanist Manifesto, and Woodrow Wilson wanting to change society and secularize it and get away from the Darwinians thought that way, to get away from this myth of God and Jesus and things like that, because they thought science was the answer and science became their religion. Well, they have succeeded so much in infiltrating our educational system over the last 100 years. In our universities, it's just horrible. And one of their weapons, which is from Saul Alinsky's Rules for Radicals, is to deconstruct society. That is their plan, okay? They teach it, actually, in schools. Marxist professors teach it. We need to deconstruct it, which means we have to undercut all of the social norms and values so we can reconstruct society. Well, so where does that attack come in? It comes in court decisions, appellate decisions, okay, where they're interpreting either the state or the federal Constitution. And that's where we need the backstop to say, no, the original intent when they wrote that Constitution is that this is what that part of the Constitution means, okay? Because that's where it's come undone, beginning at the U.S. Supreme Court, is they have pulled away from the original intent. Thank goodness Reagan came along and appointed Scalia, and then Bush won, had Thomas, and it's been very disappointing. What we thought we were getting with Chief Justice Roberts has not panned out as we like. And so I've been looking at where can I have an impact the most to try to fight this fight against this left-wing attack that's going on against the country. And so I decided that if somebody's going to do it, okay, and we have people that are an opening in the night for Chief Justice, that I needed to step in. I needed to step in because I've been active in organizations that have these beliefs. And when we lived in Corpus Christi, when I lived in Corpus Christi and ran for office, we were members of Eagle Forum. And after we moved up here years later, I found out they had an Eagle Forum here. And I remember we were members of the Corpus Christi Taxpayers Association. I think it still exists. And they were one of the groups that would come out against all the, frivolous bond issues that they would put up all the time. And so when we moved up here, in the first few years I wasn't very politically active. I was concentrating on, transferring my practice from Corpus to be up here because we moved up here to be closer to my wife's family. that lived up here in Montgomery County. But after a few years, when, and the kids were very young, we moved up here. This kid got a little older and we could, go out and about. I did run for the Chief Justice, against the Chief Justice in 2008 when he was running for his first re-election term. And I was upset at the time because he had made a ruling in a case that I had filed a motion on, and that the police didn't have reasonable suspicion or probable cause to search a motel room. And the standard is that a motel room is considered the same as a home under the Constitution. That, at least that theory still exists today. So when I filed a motion that pointed out they didn't have that, Judge Mason Martin, who was County Court 3 judge at the time, agreed. He didn't even finish the hearing once the state had testified. And so he said they didn't have probable cause to go search this man's motel room. The DA appealed it, and it went up to the 9th, and there was an opinion by Justice McKeithen that said basically no, the police can knock on anybody's door at any time and ask to search for contraband. Contraband's anything that's per se illegal, drugs, illegal weapons, things like that. And I was so against that, and I was so shocked that somebody from Montgomery County, that our Court of Appeals of all, I could see Austin maybe or somewhere, would come out against the protection of the home. And I see why he did it, because the case that they relied on in that decision came from the United States Supreme Court decision that dealt with the search of a bag on a bus in Florida, on a bus line known to be taken by illegal aliens and by drug runners, okay? Well, that's a different constitutional standard when you leave your home, okay? The home is the castle. It's been that way. The home is the castle is from a Supreme Court opinion. But he did not distinguish that in his opinion and relied on this case where you're out on the road. I was very upset about it. I tried to get the Court of Criminal Appeals to review it, and they wouldn't. And I traced, in that request to the Court of Criminal Appeals, I traced the history of search and seizure all the way back to the first Congress, okay? And pointed out that, no, that what they're talking about, your right to privacy of your home, is different than the right to privacy when you're on the road. Because there was an old case that your right to privacy was lower when they were searching a wagon to find out if all of the items that they had in the wagon had a stamp tax, because that's how they made money with excise tax. And it was okay to pull the wagon over and search it without probable cause to see if it had the stamp tax on it. But the Supreme Court back then had said, I mean, way back, some of the earliest opinions said, oh, but you cannot do that to a house. And so I was very upset, and that's the type of law and the type of originalist approach I wanted to take on these issues when they come up in the court. And he is a very good man, and Justice McKeithen works very hard. And I said so when I ran against him, that the only reason I was running is I had a different philosophy than he had. And I was a little bit criticized by him by saying, well, we're not exactly the Supreme Court, and we don't really decide those issues very much. And I said, no. What happens is the higher courts after the first level, the Court of Appeals, the Court of Criminal Appeals, the Texas Supreme Court, the United States Supreme Court, all of their appeals are discretionary, which means they only hear what they want to hear. They don't exist to correct incorrect decisions by the lower courts. And by virtue of that, most of the time, like 99% of the time, when an appellate court, like the Ninth Circuit in Beaumont, when they make a decision on a constitutional issue, that's it, because it never gets heard or reconsidered again. And that, if it's a bad decision, it can be picked up and followed by other courts of appeals. And And that's why it's so important that at that first level of an appeal, when it's a matter of right, that you get the Constitution right. That you get the Constitution right.
John?
And so that's why I'm running now. That's why I ran then. I put my nose to grindstone, went back to work. My kids are now grown. We just graduated the fourth one from college. And the oldest one's an attorney for the last 4 years from law school, summa cum laude. The second one has her master's and teaches at Texas State. She's working on her doctorate right now, and she's the mother of my only grandson, only grandchild. Very proud of him. And the third one is a nurse at UTMB, Galveston. She graduated cum laude, and she's getting ready to go back and work on a master's while she's working in nursing. And now my youngest one has her degree and is looking at graduate school or law school. But that's all thanks to my wife, who homeschooled the girls in grade school so they could get a foundation in reading, writing, arithmetic, and it's pushed them all this way. Which is why I think homeschooling is so important. It needs to be nurtured and protected. But I'm here to take any questions based on the questionnaire or not on the questionnaire, whatever you would like to know.
All righty. Well, thanks for that overview. I also forgot to mention that with me is Bob Bagley, Larry Rogers, David Smith. So Jay, with your intro, what do you bring to the court based on the judicial philosophies of those that are there now? And you mentioned that you had that one instance with Judge McKeithen. Was that pretty much his temperament and his judicial philosophy, that he didn't necessarily go exactly by the Constitution, and whatever they did would be fixed by the higher court, when we all know that's not necessarily the case?
Well, the difference I see with who sits and who's been elected in recent years on the Ninth Court of Appeals is it's lawyers who have done almost exclusively civil work, not criminal work. And where you really learn the Constitution and where the rubber meets the road is really criminal law. Because when you're in prosecution, because when we do intake in prosecution, the first thing you look for is, was there probable cause for the arrest, reasonable suspicion for the stop. And so over the years, if you do it enough, then as a defense attorney, you do the same thing. You learn how, when you're looking at the facts, how the Constitution applies and where rights are being violated. If you haven't done that, or did it just very little, many years back in your career, then you don't see those points, and they're not that important to you. It's very important to have civil experience on the Court of Appeals, because a great many of the appeals are civil, okay? And so that helps. But I think you're not as well-rounded and also in a coffee with the judges that I attended last week, as a matter of fact, they were talking about, because of the volume, how they get summaries, from law clerks who are not really clerks, they're lawyers, okay, maybe 50-year-old lawyers, right? But they call them their briefing attorneys or their law clerks. They get summaries. They don't always read the whole transcript of the trial. Okay, they get summaries of things, and which explained to me, like, I've had some appeals that have come back, and they've not mentioned some very key evidence that was in the record, and I've wondered, well, why did they not even mention that in this, And learning from their discussions last week, it's because they get summaries of the evidence and things like that. And unless the attorney, which I do in my briefs a lot, I take out what I want them to, now I do over the last few years, what I want them to know from the record, I'll quote it directly. Because of the volume, apparently, they don't have time to read the whole transcript. It takes time to work on a brief, because if you get a case you didn't try, you've got to go through and read all that transcript. And then as you're working on it, you got to go back and forth and back and forth. It's very time consuming. And so I think it's a problem with the appellate courts, all of them, not just this court, but it's the volume And so that's interesting that they were talking about telling the attorneys who do briefs, to try to bring forth the most important points to them, because from what they're saying, they really don't have the time to thoroughly review the whole record, which I think needs to be done. Once in a blue moon, you will have a court that picks up on something that neither side picked up on, that's in the record. And I think that's something that's your job as an appellate court judge, that even if the parties don't recognize some issue, whether it's a statutory construction or the application or a constitutional issue, I think that we're there to protect the Constitution, first of all, and we're there to see that justice is done. And so I think our duty is to thoroughly review the records that come in front of us. And so I think that our Court of Appeals, like I say, is predominantly civil lawyers who did civil work or civil appellate work before they got there. And that's why another reason I'm running is because I'd like to have some balance when we're reviewing, the records on cases and issues. And there are many times when the criminal and the civil law kind of interplay between each other. And I think that you only understand that if you've worked on both cases to see how they come together. Mm-hmm. And so I had one case where there was one partner alleged another partner stole something at one time. And I'm like, well, the partner can't steal his own stuff, okay? But the DA working the case couldn't understand that, okay? Because it's like, well, yeah, but this guy's name was on the documents. I said, yeah, but they had a partnership. And they couldn't understand it. So I brought civil law in to the judge, and we had a non-jury trial. The judge heard it, the judge read it, and said, oh, I understand now. General partnership, the partners both own everything the partnership owns. So one can take the stuff, or the other can take the stuff. It's not a crime, it's not a theft. And that's just an example of where, if you know the civil and the criminal and how they interweave, then that helps you when these cases come up and come in front of you. But I think the more important thing is, well, look, we need to check the record, and we need to check the record thoroughly so that we're not writing opinions based on something. I had an oral argument in another court, wasn't this Court of Appeals, thank goodness, years ago. Both of us lawyers, my client had been discharged for filing a workers' comp claim, and they wouldn't put him back to work. So we're coming up on a motion for summary judgment. So the week before that hearing, they put him back to work, right? So we go, the judge throws the case out on summary judgment, and I appeal it. And so both of the lawyers put in their brief that the plaintiff was rehired the week before the hearing on summary judgment, okay? And we wanted that known because it's like they were saying he couldn't work, and we were saying he could. So why'd they hire him back if he couldn't work, you see? And the other side was like, well, he got better, and that's why we let him come back. We're not bad guys. So I'm arguing, oral argument at the Court of Appeals, and one of the judges stops me and says, you mean that he went back, he's back working at that? Now this was listed in both of our briefs. It was in the record, okay? Both in our writing and in our oral argument at the summary judgment. And that really opened my eyes about, well, how much do these judges read? And because he was surprised, out of 3 judges, 2 of them were surprised that what was in both of our briefs had happened. That's scary.
Yeah.
So
They were Democrats, I'll tell you.
So we've had sniffing case with Toma here in Montgomery County in terms of with the visiting judge.
Yes.
Right?
What is Toma?
In terms of Toma.
What is Toma?
Texas Open Meetings Act. And is that right? And then with the Governor Perry had a problem with visiting judge.
Yes.
In terms of his veto. Do we have a problem with visiting judges being used to pass off hot potatoes?
Oh, yeah. Oh, yes. Oh, yes. Because that's the formula, If you have a high-profile case that's going to bring forth a lot of enemies, no matter which way you rule, the judges voluntarily recuse themselves. And so what happens is you have this chain going on in a county where this judge says, well, I know one side, so I'm going to recuse myself. So they pass it to another judge. Well, I know one side, so I'm going to. And they keep doing that, and you're out of judges, and you have to bring somebody in from out of town to sit and hear the case. It's political cowardice, you know. Now, there are times when if you do have an ongoing relationship with an attorney or a party on the case, which means, you know, you're in the same church every Sunday, you're on the same church committee, your children are dating, or I believe if you were the chief fundraiser on this, you know, the judge, if they were your chief fundraiser on the campaign, even though the rulings don't say that doesn't matter, I think that's enough of an appearance that you should recuse yourself. Because the last thing that we want people to do, it makes them so bitter if they believe that they have not been ruled against out of a sense of justice, you know, right and wrong, but because of, you know, there's somebody buddy that's on the bench, you know. There's some, you know, backdoor politics going on. And so if a judge just simply has a hot potato that they have to handle, that's really their time to shine, you know, because the best decisions, whether they be from the trial bench, I like them from justice of the peace courts, is when, and of course you explained it in an appellate court, in your opinion, is when you say, this is what the law says and how the facts are applied, and this is why, okay? Because even if people don't like the decision that they got, if they know how you reached it, and it was reasonable, they can live with it, okay? And they may not agree with you, but they can live with it. And that reinforces our system of justice, you know? And so when you have, you know, backdoor deals going on, what we have a judge we've never heard of that's been shipped in from out of county, and you know, and we don't know why they ruled the way they ruled, because trial judges can just rule like up or down, right? Now, with the appellate courts it's different, because there's an opinion most of the time that's written, almost all the time it's written. But the real problem with the visiting judge problem is at the trial bench, you know, which is the most important part, because appellate courts don't take any evidence, okay? So if the judge who's flown in there to take over doesn't allow certain evidence in that destroys your case, that's the record. That's set. All the Court of Appeals can consider now is what came in, or the fact something was excluded or denied. And if you don't know what's excluded or denied, then you can't say it should have come in necessarily. You know, you have to do a bill of exceptions. A lot of lawyers don't do that. And you can do that whether the judge is there or not. You just get the court reporter and you start saying, here's what our evidence would have shown, and you've got to have that in the appellate record. Because case after case, appeals courts say, well, you're saying that so-and-so should have testified and they would have had some evidence, but you didn't put in the record what evidence that you think they would have brought forward, and therefore we can't consider it, you know.
Okay, in your 34 years, I'm assuming that 7 years you spent in Corpus,
That's correct.
but since then you've had your private practice for many years. Approximately percentage-wise, in your practice, how much has been civil and how much has been criminal?
On my jury trials, it is almost half and half. Initially, you know, I had done, by the time I left the county attorney's office, I had done about 60 criminal jury trials. And so after that, when I went out, most of my jury trials were civil. That's more of my pursuit, because I was trying to build a civil law practice since I'd done so much prosecuting. And not very many criminal defense trials. And I'll tell you the reason why. I think the reason why is, you know, I know what the law is. I had enough juries that I know how they're going to look at the evidence. And if you explain that well to your client, in most cases, people that get indicted, it's not an accident. They really did it. That's, you know, the police aren't that stupid, the DA's not that stupid. Sometimes there's a close call, or that somebody's got something wrong or messed up, and you have to have a trial on that. But for the most part, people that get arrested and get indicted, or, you know, and charged and they're in court, they did it and they know they did it, you know. And I'm not one of these that I'm gonna have a trial and try to lie to the jury and see if we can and maybe get this guy off, you know. It's like, no, juries can see through any type of facade. I'm sorry, I don't know how many juries y'all
Except with a glove involved.
That's true. Well, I think that was racism involved in that case. But the point is, and I tell clients, I say, look, you know, they try to come up with some ridiculous theory. I said, you can't. The jury's going to see through that, you know. When you have enough trials, they're going to see through that. And it's the same thing. If the state has problems with their case and they won't admit it, then I'll tell the DA prosecuting. I said, well, I think the jury's going to see through that. Well, we'll have a trial. Okay. The jury sees through it, you know.
So most of, I guess, you'll have to spend, I guess, Monday to Friday in Beaumont, because that's where the court is.
Yeah. Well, the days that when they're having oral arguments, or when they're having the meetings, the submission documents where they're meeting and voting on, you know, how they're going to rule on this case or that case, yeah. A lot of what I understand they're doing now, they can use Skype and things like that to communicate with each other and to send documents back and forth, because a lot of it is opinion writing time, and somebody's assigned the opinion, and it gets circulated, and then it comes back with comments and things like that.
But the staff is there, so I guess to utilize the staff, you need to pretty much be there.
Well, that's true. You can get staff on Skype or,
Yeah,
you know,
sure.
on the phone or whatever. But no, I do a lot of driving anyway. You see, I'm from Corpus Christi. I still do some cases down there. I do cases in Houston. I've done cases all over the state, basically.
And you don't
Dallas,
have to
Austin.
close down your private practice.
Oh yeah, if you take any bench, then you cannot have since you're a JP, you can't have a practice on the side because of the potential conflict of interest.
One last question, and then I'll turn it over to Bob. In one of your answers about Texas Constitution and other documents, the United States and the Texas Constitution and other documents, and you alluded to this earlier, you were lied to in law school, as you said earlier, by Professor Rottenberg.
Rottenberry, yes.
Rottenberg.
He's probably dead now.
Well, I was just curious, how did all that work out for him?
They loved him
He's
at the
dead.
university.
Unbelievable.
Unfortunately, that's a U of H, which is a semi-conservative law school, which that's the best we've got, you know, in their trouble.
Semi.
All right, Bob?
Civil asset forfeiture is a big issue and a big problem in Montgomery County, and I'm suspecting most of the state, and I've heard it in other states as well, where people are pulled over and assets are seized and not given back, and then they're not even found guilty for it, and they don't get their stuff back. Waco with the massacre that took place up there on the bikers was a prime example of that. There doesn't seem to be due process of law, and I'm not sure how much of this plays into the position there at the court, but what are your feelings on due process?
With regard to the civil asset forfeiture?
Yeah, and in general.
Well, I think that the statute had a good-hearted intent when they came up with it. It's like, well, we'll give people an incentive to go out and bust drug dealers and all this kind of stuff. And when I was with the county attorneys, the sheriff's office, all the agencies, they would form task forces. And there'd be one in this part of the county and one in that county up there and everything else. And then they would share in the proceeds. They had a written agreement on how much they would get. And they even, once they seized some drugs, instead of destroying them, they kept them and started using it for reverse buys, which your mom knows what that is. So now, instead of seizing drugs from drug dealers, you show them the drugs and you're seizing the money. And then you start getting, you know, real fancy, unmarked, you know, detective cars, and you get equipment, and you get high-dollar seminars and all that kind of stuff. And I think the legislature, I understand that there was an attempt in the last session to try to modify the law, that my belief is they shouldn't be able to seize an asset like that unless they can show beyond a reasonable doubt that it's a derivative of criminal activity, of everybody involved, okay? There are times when a drug dealer will take his mother's vehicle, right? Or his sister's vehicle, right? And then go do a drug deal with it, and they're gonna grab it, they're gonna seize the vehicle. And it's like, well, that is not fair to the mother or the sister, okay? But statutorily, they're like, well, we're within our right to do it. And so what we do on those cases a lot of times is we'll file an answer, we'll object to it, we'll try to produce, you know, evidence that it is not connected with criminal activity, and then it's like I'm working on a case right now. It's about $54,000 that night from the sale of a semi-rig. Okay, nope, it's criminal activity. So what'll happen is we end up saying, well, look, we'll give you some of it if we just can get the money back, and you know, and not have to go to trial and appeal and all this kind of stuff. And the DAs are using it. And another problem with cash is anybody with DEA will tell you that if you check out any dollar bills or $100 bills or $20 bills, they're going to have traces of drugs on them, whether it's marijuana or cocaine. So if you want to say, well, scientific, well, if you've got drugs on the money, why, obviously it's, well, no, people who use drugs pass those bills, and bits of it come off on those. And because that was the big thing they were using back in the 90s and early 2000s. Well, you know, we've done some testing, and it's testing positive for cocaine or whatever. Are you kidding me, you know? And so, no, I think the legislature needs to change the law, and change the standard of proof on that to protect the innocent in cases, you know, where they're maybe related to or connected with bad actors or bad actresses, you know, because it's out of control. And I also thought, and I don't know if I put it in this question here, because somebody asked about it, but if you take away the incentive on the backside and say, okay, all the money you're bringing in for your entity, whether it's for a city, whoever's a member of the task force, city, county, or the feds, or whatever, if all the money you're taking in goes to the general fund of that entity, and whoever runs that entity, the city council or the county commission, they decide how to spend that money. Because when I was in county attorneys, we would get asset forfeiture money, and what my boss would do with it was any money, now he had to keep it in a separate fund statutorily, but to spend any of it, he would always submit it to the county commissioners and the county court and say, I want to use it to buy this or to pay this or to do that, and he would get it approved before he went to spend it, because he didn't want an accusation coming that he's got a personal stash and he's, you know, paying off friends or buying goodies with it and things. And I think that should be the law, the rule, is that those monies all have to go to the general fund. If you do that, then I think law enforcement is going to be doing these pursuits for law enforcement purposes,
Right reason.
not to try to get money for fancy things.
So you believe in the Constitution, and I'm guessing that you don't believe in creating law from the bench, right?
Oh, absolutely not.
But would that stop you from writing a proposed law and sending it to the legislature, yeah, for something like this? And would you be willing to do that?
Oh, not as a member of the court, yeah, not writing it into opinion. Say, my opinion,
Right.
the legislature should adopt this
Right,
law.
no, from you as an individual.
No, I have no problem that, just from the standpoint of if a legislator or, you know, senator or a representative says, well, what do you think would be good language, you know, if we're going to try to fix this, I have no problem with looking at that and saying, well, I think that to be constitutional, it should say this, or the standard of proof or whatever.
But would you be willing to take the lead? Not for them to come to you, but would you be willing to take the lead to make changes that need to be made in our judicial system to make the change, to get them to pursue a new law?
You mean to change any statute or something like that?
Exactly.
Well, even though you're a judge, if I were a judge, I still have a right to my First Amendment right to express
Right.
my opinion
Right.
about something.
So would you be willing to do that
Oh, sure.
proactively instead of waiting for them to come to you?
If I think that, yeah, that there's like nobody's doing it type thing, like I'm running for this office because the people that are running it are not, they don't have the same mindset I have, same thing. If it's like, look, somebody needs to do this, then I have no problem
Okay.
speaking out and suggesting that, look, there should be this change. And these are the reasons for it, you know? That doesn't bother me at all.
Okay, thank you.
So is there any part of law that the appellate court deals with that you haven't touched at all? I mean, you spoke about, you've done criminal, civil, probate, families, or anything within, you know, what the purview of the appeals court would deal with that you haven't seen?
No, for what our Texas Courts of Appeals handle, what they review, you know, I've done all those areas, okay? Not absolutely every kind of case, and not every kind of case have I appealed, but as far as, you know, working on you know, criminal appeals and issues in criminal law and civil appeals and issues in civil law and family law, it's kind of been there, done that. And like I said, I've also done federal cases, you know, where there's been criminal or civil issues under federal law or constitution. And so that's why I would be comfortable, no matter what kind of case came in front, understanding, you know, sometimes you don't see the case in the proper context because you don't have experience in that area of law. You can come up with a really weird decision. And I think sometimes that happens. If you've ever seen cases where they say, our previous opinion has been withdrawn, and we substitute now in place this opinion after a motion for rehearing. You ever notice that? I bet Bob had. And I think that what happens sometimes is you get some field of law that the one writing the opinion is not familiar with, and you kind of trip on something. Kind of a everybody knows type thing in this type of case. And then it's brought to their attention after the opinion is written and the decision is made. So they have to pull it back, get the other judges involved, and then correct that, you know. And I think that's why those things happen. But I think that's something I think that I could help avoid by understanding the context and how the different laws can interplay between criminal and civil.
Do you have any idea, one quick, do you have any idea what the ninth percentage is, criminal versus?
I used to know that. I thought it was about 1/3 criminal. That was years ago. It was years ago. I know it's pretty steady. Reversal rate used to be something like 8 to 10% for a reverse or modify on civil, and less than 5% reversible on criminal. Very few reversible on criminal. Yeah.
So what would the rest of it be if you had 30% criminal, how much civil?
Civil.
So the rest civil?
Yeah,
Not
where-
family?
Well, that family is civil, I consider family
Oh,
civil.
okay.
So,
Okay.
in other words, people are appealing a custody decision, a divorce decision, the admission of a will, a probate decision. A lot of the ones that go to appeal are the contract disputes, usually, you know, between different companies, you know, construction or whatever. And you know, they're very dry, and there's a whole lot of issues and points to be made. And there's a lot of briefing on those because the firms are paid, you know, by the page to generate their documents. But But it's important because it helps the flow of commerce, and that's what we want, and especially in this Trump economy. You know, we're going back to business, which I love. Americans are getting back to business, all the way from the big corporations down to the lawn guys, you know, and the janitorial services and stuff like that, just setting up their own businesses. And so we need to make sure that our laws, you know, help commerce flow, and by, you know, having a fair resolution when people get into disputes, which is usually from not having things in writing. And I think that one of the duties of an appellate court, both the state and the Supreme Court, is to, you know, interpret the laws the way the legislature intended. And if they're missing something, to say it, okay, that I cannot change this law, okay? And I may not like this decision, but it's based on the law written by the legislature. And much as that may hurt, you know, that our job is not to try to change the law or what it means for some perfect circumstance it's going to result in. For what that's worth, I think.
Okay.
That's what I exist.
Sounds good. Why don't we wrap it up if you would like, and take up the 5-minute closing, and then we'll call it a night.
All right. Well, like I said, I've been busy finishing raising these 4 daughters, and again, doing all kind of cases, and doing it in multiple counties. Like I say, cases in Houston, and in Cold Spring, and in Huntsville, and Austin, and, you know, all over the state. Corpus Christi, Victoria, places like that, Dallas. And so I've developed a broad range of experience in multiple kinds of cases, okay? Civil litigation, either prosecuting a case. I did one recently for a disabled vet that had a defective roof, you know, and we got him satisfied. And I've defended small business people who didn't have the money or the wherewithal and didn't buy, you know, insurance to try to pay for lawyers if they got wrongfully sued. And so I've tried to help small business people, you know, hang on to what they've got, what little they've worked hard for and over the years and have put together when somebody's making, you know, false or exaggerated claims against them. And then I've helped, like I say, criminal defendants, and you know, I've represented people, and what I say, and I tell other lawyers, young lawyers too, I said, we don't defend our client, we represent our client in a criminal case. Our job is not to try to cover up what they did. Our job is to make sure their rights are complied with, whatever rights they have. And and frankly, if they're guilty and they did it, then you take a different approach. It's like, all right, then what will the consequences be? What will the punishment be? And that's what we need to work on, rather than trying to lie to a jury and fool them into thinking you didn't do something, you know. So along the way, I've done it with conservative values, you know, Roman Catholic. I've been pro-life, more so since I got married, and my wife had a lot of influence on that. And not afraid to say I am pro-life, not anti-abortion, but pro-life. Have been for, you know, low taxes, against frivolous bond issues, to buy fancy things for cities or schools, unnecessary things. I believe in limited government, and always have. I would like to see the size of, especially the federal government, but all governments shrunk up. I understand they pushed through a raise for federal employees. I believe they should freeze the salaries of federal employees. The last time I heard, the average federal employee was making something like $105,000 a year. The average private sector was making something like $55,000. And plus their retirement is a golden parachute, you know. So I've always been conservative along those lines. That's why I joined Eagle Forum. That's why I joined the Tea Party when it developed. Before that, I was in the conservative coalition in Montgomery County, and supported, you know, conservative candidates as much as I could. And when the party would do things that were conservative, back at 100%. When the party backed away from those principles, then I kind of backed away from the party. I think we're on the right track. I think President Trump has us on the right track. I'm pleasantly surprised at what he's done, because I was a big Ted Cruz supporter. And so when you look, again, when it came down to the last weekend, considering this race, and I saw my opponents, who are all good people, and, you know, good lawyers and all, I believe that, I didn't think they had the same philosophy that I had. And Justice McKeithen has now been on the bench for about 18 years. There are 2 other judges that have been there since 2005. They're not going anywhere. So whoever gets on that court will probably be there for a long time. It's a 6-year term, but it could be 12 or 18 years. And so I just felt like I think I need to step up. If I want the country to try to return to our values, our Judeo-Christian heritage, I can't sit back and let somebody else do it. I've got to come forward and put my name out there and do what needs to be done to try to get elected in this position, so that we have someone who believes in these values on the inside, instead of on the outside complaining about it. And so I would appreciate your support and anybody else's support on this fight, you know, that I'm taking up to try to get on the inside, let me say, and have a conservative state of mind, a conservative bent on these in the judiciary, in the appellate judiciary.
Okay, great. Thanks again for coming in. Appreciate it. Good luck in your campaign.
Thank you. Thanks for
All right.
having me.
Thanks, have a Merry Christmas.
So have you looked at, so what's Montgomery County population